Welcome, everybody. My name is Paula Price. I'm with the People's Law School, and we are delighted to have you join us here today for today's webinar, Renting in British Columbia, Town Hall Edition. We have two amazing speakers. We'll be introducing them more formally in just a moment. They are Lisa Mackey, a lawyer with Alexander Holborn, and Robert Williams, information officer with the Residential Tenancy Branch. And our speakers will be answering everyday legal issues as they relate to renting in British Columbia. What you can expect today, we have 60 minutes together, and we will be providing answers to your questions. What you'll receive is legal information, not advice. So if what you're looking for is the law as it applies to your specific set of circumstances, we would encourage you to reach out for legal advice from a lawyer. You're welcome to contact Lisa. Her information is on the screen. You're also welcome to reach out to the Residential Tenancy Branch. The information is also on the screen. The information that we're sharing today is current as of today. We are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose people continue to live on and care for these lands. And we invite everybody who has joined us today to consider where it is that they are joining us from. We'd also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation of British Columbia for providing financial support for today's webinar. Finally, we would love to introduce our speakers. We have Lisa Mackey. Lisa is a lawyer with Alexander Holborn. She is a leader of the Residential Tenancy Group, the Rental Property Group, and the Strata Property Practice Group at her firm. Lisa represents both landlords and tenants in her practice, and she is a return speaker to the People's Law School. Lisa, welcome.
Thank you for having me again.
It is such a pleasure to have you. We also have Robert Williams. Robert is an information officer with the Residential Tenancy Branch in British Columbia. The Residential Tenancy Branch, for anybody who's new to it, provides landlords and tenants with information and dispute resolution services, as well as resources about the rights of landlords and tenants. And Robert is also a return guest to the People's Law School. We are so delighted to have him. Welcome, Robert.
Great to be here.
Wonderful. And with that, we're going to jump into our questions. So the first question that we have is for Robert. And the question is, it's from a landlord. Are the rules different if I'm renting to students? Does age matter? Are the rules different if they or we share a common kitchen?
Okay, so right off the bat, are the rules different if I'm renting to students? Not necessarily. So there are some exemptions under the Act, specifically Section 4B, that basically states if the living accommodation is owned or operated by an educational institution and provided by that institution to its students, the Act does not apply. So in that specific case, it doesn't. Otherwise, students are typically afforded the same rights and responsibilities under the Act. Now, if we're talking about age, this is an interesting one. So as far as age requirements, Section 3 of the Residential Tenancy Branch asserts that a person who has not reached 19 years of age may enter into a tenancy agreement or a service agreement, and that agreement and this act and regulations are enforceable by and against the person, despite Section 19 of the Infants Act. So Section 19 of the Infants Act specifically refers to so when and if contracts with minors are enforceable. Now, does that mean that you could rent your unit to a 5-year-old? Probably not. So I don't think that's really been tested yet, but I imagine that if that were the case, probably not. But there is some leeway because there are tenants that are 16, 17 years old. Sometimes people graduate high school early and they attend university early, or for whatever reasons, they could be like emancipated youths or something to that extent. And yeah, the act would still apply despite the fact that they are not an age of majority in BC. So finally, are the rules different if we, they, the landlord or tenant, are sharing a common kitchen. So Section 4C of the Residential Tenancy Act states that that the act does not apply to living accommodation where the tenant shares a bathroom or kitchen facilities with the owner of that accommodation. So if the landlord is doing like a room boarding situation agreement and physically shares a kitchen or a washroom with said student, the act would most likely not apply.
Fabulous. Thank you so much, Robert. Very, very excellent, concise answers. Wow. Lisa, you are next. This is a question from the perspective of a renter. Can a landlord ask you to submit bank statements? I understand them asking for proof of employment and references, but bank statements? I'm not buying the place, just renting it.
Yeah, can a landlord ask for them? Sure. Should they? Probably not. Two different styles of question there. So for the answer to this, we don't actually look at the Residential Tenancy Act. So it's a little bit funny, is that the Act doesn't really comment on rental applications or rental interviews or any of that important process involved with creating a residential tenancy. Where we look to this is something called the Personal Information Protection Act. So in our province, landlords, private sector landlords, are required to manage and collect and dispose of people's personal information in a manner that respects their privacy rights. And so the question always is the landlord asking the right information? Are they asking for too much? And the question usually is it reasonably necessary for the landlord to get this information from me in order to decide whether or not to rent? So bank statements are a bit personal, right? They'll show all of our records. They show my purchases from McDonald's. I might not want to disclose that to anybody, how frequently I dine there. But the question is always, is it reasonably necessary? So there might be some circumstances in which a landlord is not able to assess the creditworthiness of an individual. So they're not employed, they're new to the country, there's no credit history, and there might be a reason to say, well, listen, we need a copy of your last 3 months bank statements with things redacted, but to see whether or not you have sufficient money to afford the rent. That might be a reasonable justification. But in my experience, it's pretty onerous to ask somebody for copies of their bank statements. There's a lot of information there, and there's less intrusive ways for landlords to vet an incoming tenant.
Beautiful. Thank you so much, Lisa. The next question is for you, Robert. And this is from the perspective of a landlord. We own an apartment and wish to rent it out for at least a year and then move back in or sell it. Are we obligated to let the tenant know? Are we obligated to let the tenant know when we rent to them? And if we decide to sell, how can we inform the tenant of our decision so we can clean up the apartment before putting it onto the market?
Okay, so there are a few words in here that sort of jump out. So first of all, you want to rent it for at least a year and then possibly move back in it. Well, there is an option for that, but you would have to have a specific date in mind that you plan on moving back in. So if you wanted to enforce something like that, you would have to do so at the beginning of the tenancy. So firstly, on page 2 of the RTB1 residential tenancy agreement, like the standard agreement that you'd get from our website, under the beginning term of the agreement, you can select box E, which states at the end of this time. So you would include with the date that the tenancy ends. So at the end of this time, the tenancy is ended and the tenant must vacate the rental unit. This requirement is only permitted under circumstances prescribed under section 13.1 of the residential tenancy regulation, or if it's a sublease agreement as defined in the act. So now, within this option, the landlord actually must provide the right, write in the reason that the tenants must vacate at the end of the tenancy. And there's only one reason allowed, and that is that the landlord wishes to occupy the unit. And it must clearly state that, and then both the landlord and tenant must apply to this section. And this has to be done upon signing and initializing the tenancy agreement for it to be effective. Now, the law changed in July of this year. So previously, let's just say landlords were using that as a loophole because there was really no consequences if they used that clause and then re-rented the unit or sold the unit after that, because it was all kind of deemed under the landlord's use of property, so they can sort of do what they want. But as of July of this year, the act has actually changed to sort of stipulate that if you require the tenant to vacate at the end and you enforce that vacate clause, if you do not move into the unit within a reasonable amount of time and occupy the unit for at least 6 consecutive months, then you could have basically enforced that vacate clause in bad faith and could end up having to pay the tenant 12 months rent compensation as a result. So, so definitely when it says, they want to rent it out for at least a year, and if they want to move back in, so they would need an exact date, and they would actually have to move back into the unit to actually enforce that. Now, as far as selling it, you do not have to notify the tenants pretty much at all during the entire selling process. There's no obligation for that. But if you require them, so how it works is you can't actually require a tenant to leave to sell a property. That's not actually allowed under the act. But what you can do is sell the tenanted property, and then once the purchase is complete, and once the conditions of the sale have been lifted, and if the purchaser or a close family member under the act, as defined under the act, wishes to move into the property, then the purchaser can make a formal request in writing to the seller to serve a 2-month notice to end tenancy for landlord's use of property. And the tenants will have 2 months to vacate, and they will be entitled to 1 month's rent compensation. So basically that would be the way, that's how a tenant would essentially at the end of the day be evicted, to accommodate the purchaser so that they can move into the property.
Fabulous. That is so helpful, Robert. Thank you. And we have more questions about situations where a home is purchased with tenants. So just forecasting a few of the questions to come up. And I just note that the standard form renting agreement that you referred to has been, there's a link to it has been provided in the chat. So for anybody who wants that, you can also find it on the residential tenancy website. Thank you. And very helpful also that recent update regarding the July update. I think that's something that is obviously of interest for anybody who's thinking about setting up a clause like this, and what is the requirement? If I do say that we're going to move in, do I need to move in? What happens if I don't? So thank you so much for that. Lisa, we have another question, or the next question is for you. It's a renter asking, as a single tenant in a dwelling with both the landlords, a couple, living directly above me, what is considered reliable documentation? Is it enough for me to communicate with just one of the landlords? I prefer to avoid one of the couple.
I feel like there's a story there in terms of the relationship with half of that couple. So essentially, the first thing I do is I look at the lease. So I look at who is identified as my landlord under the lease. So if it's the problematic half of the couple, you're going to need to communicate with them unless you get their permission to communicate with their partner. So as their agent or what have you. If they're both listed, or if the other half of the couple is there, then in my view, you can communicate with your pick. Usually what I do is I'll just get clarity at the front end in terms of if I have any issues during the tenancy or questions, how am I to write to you? So is it posting a notice on the door? Is it through email, which the Residential Tenancy Act allows now if everybody consents to that as a method of service? I just want clarity. But no, there's no hard and fast rule in terms of wanting to avoid one half of that dynamic duo over the other half. It's just better to get clarity into who is actually managing that property.
Absolutely. Fabulous. Thank you, Lisa.
You bet.
Next question is for you, Robert, from a landlord. I've acquired a home with a suite. The tenant has lived there for about 30 years, pays half the market rate in rent, and is a pensioner. The suite is in bad shape, peeling wallpaper, floor shot, bathroom fixtures need replacing. If I do a makeover of the suite, it'll be too pricey for the tenant. What are my options?
Well, there are basically two options here if the landlord wants to go through with that with the renovation. So the first one would be essentially evicting the tenant to do the major renovations. So that process has actually changed quite a bit last year. So effective July 1st, 2021, under new legislation, if a landlord wants to end a tenancy for extensive renovations or repairs, they need to first apply for an order of possession from the residential tenancy branch. So previously, they just had to get all the permits required necessary to do the renovations, and then serve a 4-month notice. And then the tenant has the right to dispute that notice if they feel that it's not being done in good faith or the renovations aren't significant enough to warrant evicting the tenant. So now the landlord actually has to get all the permits first and then bring basically the scope of the project to the residential tenancy branch, where an arbitrator would review it and basically decide whether or not this meets the criteria to evict the tenant. So effectively, there will be a dispute resolution proceeding where an arbitrator would decide if ending the tenancy is the only way to complete the work. So just one point to note, any notice received on or after 2021. So if a landlord were to just directly get, because they're still available on our website. So if any landlord were to just directly give a 4-month notice for major renovations now, it's not valid unless, because they have to go through that process first, with the one exception of demolishing a unit. So if you want to demolish a unit, you actually don't need to go through the whole process. You just need to get the demolition permit first and then serve the 4-month notice, just like you did in the past. So the second option, which probably won't work with this particular tenant, as it's stated that it will be too pricey. It may be too pricey for them, but the landlord could always apply for an additional rent increase for basically capital expenditures. So recently, the residential tenancies regulations allows landlords to apply for additional rent increases when they have completed necessary repairs to the rental unit or building. These provisions encourage landlords to invest in their rental properties by allowing them to recover some of those costs through modest rent increase approved by the residential tenancy branch. A landlord may apply for an additional rent increase if the landlord has incurred eligible capital expenditures to the residential property where the rental unit is located. So capital expenditures are eligible if they are incurred for the installation, repair, or replacement of major system or major components for one of the following reasons. So 1, to maintain the residential property in a state of repair to comply with the health, safety, and housing standards. 2, that has failed, its malfunctioning, is inoperative or at the end of its useful life cycle. Or 3, that achieves a reduction in energy use or greenhouse gas emissions or an improvement to the security of the residential property. Now, to be eligible for these capital expenditures, the landlord must also establish the following. So 1, the capital expenditures must have been incurred within the 18-month period prior to applying to the residential tenancy branch. And 2, the capital expenditures are not expected to reoccur for at least 5 years.
Okay. Thank you very much, Robert. That's very, very helpful. Lisa, we have another question, which is also about inheriting a tenant. So in this case, landlord again, I inherited a tenant from an owner I bought from. In the tenancy agreement, it states that the owner pays for the utilities. Can I ask the tenant if they are open to the idea of paying a portion of them just to see if they're open to that idea? I asked my property manager to ask, but they refused to ask the tenant.
So when you inherit a tenant, you literally step into the shoes of the former landlord. And we might not like the fit of those shoes. We might have selected a totally different shoes, totally different tenancy agreement, but you're stuck with it. So if the lease contemplated that utilities were included in the rent, then unless you get the tenant's written agreement to amend your lease that says utilities will be paid separately, then you can't actually force them to change the rental payment amounts, or to separate a service that they've been getting already under their existing rent. There's no harm in asking. So I often encourage people, if you are looking for a change to the tenancy agreement, whether it's payment of utilities or including a no smoking clause, or having something else that addresses a building issue. So you've got a new recycling program and you want some of that formalized in your lease, there's no harm in asking. The only hard limit is you can't force that change onto the existing tenant. You've just inherited the lease and everything that comes with it.
Beautiful. Thank you, Lisa.
You bet.
Robert, this next one is for you. It's from the perspective of a renter.
Mhm.
I have been renovicted twice by the same agency and am now in my third building with them. There's a pattern of them not informing tenants that they have plans to demolish or renovate their buildings. Plus, they don't provide assistance when there was they didn't provide assistance when there was a moth infestation in my former building, or properly clean one of the units I moved into. What can I do to protect myself from being renovicted again and to get better support when there are issues?
Mhm. So yeah, so basically, as I mentioned in the previous conversation, that the evicting a tenant due to renovations process in BC has drastically changed. So previously, something that was a 4-month notice that a tenant could dispute is now something that at this point takes about 11 months to complete. So that's almost the full length of a tenancy. So it's the if you are if a renoviction is on the table for you, it's going to take the landlord quite a bit of time, and you will be informed basically at the time the landlord applies for dispute resolution. So you're going to have at least 8 months prior knowledge before they do that, and you will be able to voice your opinion and such at the hearing. If you feel that this is sort of a pattern that's being done in bad faith. It does say in this question if the landlord has plans to demolish the unit. So again, like I mentioned before, that process is still the exact same. So there's really not much you can do about it. That does happen all the time, where landlords will just bring a tenant in for maybe 6 months, but then the true nature of it is they want to essentially, they're waiting for the permits to come in to demolish the unit, and that's all they're really doing. So unfortunately, there's no real way around knowing what the landlord's true intentions are. And the reality is they could change daily. So I mean, they could have planned, to have this place, but the housing market and whatnot could dictate otherwise. So their plans could change. So fortunately, there's no crystal ball to know what the landlord's true intentions are. Even if you did, you don't know how they may react in the future. As far as moth infestations or properly clean the units, typically those sorts of things you would address while you're still living in the unit. You could put a letter in writing to the tenant or to the landlord to be specific about what it is you want them to do. You want them to, hire an exterminator for the moths, or you want them to, have somebody come in and clean your unit before moving in. And if they don't do it by a deadline you provide, you could apply for dispute resolution, and an arbitrator could potentially order them to do those things. Your only real option, if you had moved out of the unit, like it sort of implies in this question, would be to seek financial compensation. And that's, for those two things, that could be sort of a tricky thing to prove, not necessarily prove, but associate a monetary value to. So you could go after the landlord for compensation for not dealing with a moth infestation or not cleaning the unit, but you would also have to be able to prove that you've made these requests to the landlord, because they could possibly have not known this. So you'd have to be able to at least show a pattern that you've made the request and they've denied that.
Super. Thank you. It's very helpful, Robert. Very practical. Lisa, this next question is for you, also from a renter. We have lived in a nonprofit complex, not a co-op, for over 5 years. Last week, the manager asked us to provide a copy of our auto insurance because ICBC changed our license plates, no decals, this year. While we understand being asked for a copy of our house insurance, we question whether they have the right to ask about our car insurance, which is privately owned property. When we asked why it was necessary, the answer was that they requested it of all the residents.
I love that answer. That justifies the
We just asked
intention. Well,
everybody.
I asked everyone. It wasn't just you. Don't worry. Well, there's a couple of components to this. So insurance is a good thing. So there's a lot of tenancy agreements across the province where a landlord will want, as a condition of renting to somebody, that they get renter's insurance, or if they're parking in the parkade, that their vehicles are licensed and operational and insured. And so when we had the change to the insurance decals, there wasn't really a way for landlords to investigate whether or not tenants had actually obtained the insurance that their lease might require them to obtain. So the first place I look is, does my lease require me to have vehicle insurance in order to park in the parking area? And what are the consequences if I don't? And so typically landlords now will just ask for proof of insurance, particularly if it's a mandatory requirement for parking in the parking area. Say, show me proof of insurance, and then we're all good, so to speak. But I usually go to the lease. The one goal of landlords here is to want to make sure that everybody's interests in property are protected. And so they want to make sure, if you're parking in the parkade, that there's available insurance in the event of an accident or property damage or what have you. So the intention might be good there, but I would definitely have a look at the lease and see whether or not that is required of me in order to see whether or not my landlord is reasonably asking me for information.
Beautiful. And I'm going to throw one out of left field at you, Lisa.
Sure.
And I don't know if a strata act would apply here. They're talking about a nonprofit complex, but I have seen that for some strata within the bylaws, they might have a requirement, or is that a requirement you might see in a bylaw? That
Yeah,
vehicle-
certainly. And absolutely. And we're not really sure about what not-for-profit complex means. It could be a housing society. It's probably not a strata corporation, but you're absolutely right, Paula, that some strata corporations will have bylaws that require, if you're using the common property parking area, that your vehicle is licensed and insured. They might have other parameters as to how you can use the parking area or what you can store there. And so when you're a tenant and you're leasing in a housing cooperative, or if you're leasing in a strata corporation, the other layer to look at apart from your lease is the bylaws, or what are my building rules that apply, because they will apply in addition to whatever your lease agreement says. So great question. So when we're living in a strata, you're also living with the laws of the kingdom, so to speak. So you want to make sure that you don't upset the royal family and step in it when it comes to parking requirements, for sure.
Beautiful. Thank you so much, Lisa. And we know Lisa is the she spoke at our strata webinar last year. She's very knowledgeable in the strata area. Robert, this next question is for you, and it's from a renter. I'm renting an apartment in a seniors building. When I moved in 8 years ago, I signed a form agreeing to pay $295 a month for one mandatory meal a day. It was raised to $345 a few years ago, and then this year jumped to $535 a month, an increase of $190. We're told it's mandatory to pay or we'll get evicted. Is that not a threat? Extortion? Is it legal? It's a huge amount for one meal a day. The cooks are not trained cooks. Is there something I can do?
Well, if you're getting meals, the act may not apply to your situation. So under Section 4, Section 4 base of the Residential Tenancy Act basically goes through and says all these different rental dynamics that don't apply under the act. And one of them is if you, I don't remember the letter specifically offhand, but one of them is if you are receiving services from the landlord. So if they are providing you with meals, that's a pretty good indicator that the act does not apply to your living situation.
Okay, thank you, Robert. The next question is for you, Lisa, which is, I live in a complex with about 185 townhouses. Last year, with the landlord's permission, I put a movable basketball hoop in front of my unit. A few days later, a strata council member came to my home claiming to be the complex manager and ordered me to remove it, saying it could not be put anywhere. The very next day after I sold it, he came back and said, "Oh, why did you sell it? You could put it in the corner. I'm so sorry you sold it." There are 3 other houses here with a hoop in front. I wrote to the strata and asked for permission. They replied, I cannot have a hoop. If the other houses have it, I should report them. I don't want to report anybody. I'm happier to see other people happy. I'm not Canadian. I'm not a unit owner. My question is this discrimination?
Mhm. So it sounds like the council member doesn't play basketball or like basketball.
Mhm.
And this is one of those tricky situations because when we have a townhouse complex, it's probably a strata corporation. I don't know what their bylaws are. I don't know if they require requests to be made to council for permission to install basketball hoops or any other sporting equipment in the driveway or anywhere else. That's the first place that I would look is what does my community regulate in terms of me putting up a basketball hoop. And just as a reminder, it's not just going to be what your landlord says, it's also going to be what your strata council says and what your community says as well. The question, is it discrimination? Well, no, I don't see anything that would violate the Human Rights Code. We might want our recreational pursuits protected, but that's not a protected ground there. But the first question I would have is, does the community have special rules about where I can put up certain equipment? Stratas are funny little creatures. Some will be very, very relaxed with respect to how you can use and enjoy your property. Others will be more heavily regulated. So depending on where you live, you might have no issue putting up a basketball hoop. And if you live in the next door community, you require a whole lot of paperwork to be signed and approvals in order for you to do that. So the first question always is look at your bylaws. What do they impose on me? And if there's any questions for council, you can always request a council hearing and an opportunity to speak before your council and express concerns, ask questions. And so that's another avenue to sort of resolve what might be a miscommunication.
Beautiful. Thank you so much, Lisa. The next question is also for you, Lisa. It is from a renter. I gather that when a renter is renovicted, the notice period is 4 months, and the 4th month is rent-free. I've learned that Vancouver has adopted a tenant relocation and protection policy that provides additional financial compensation to the renter depending on the length of the tenancy. For example, if a tenant has lived in the unit for 20 to 30 years, they receive 12 months free rent or a lump sum payment in lieu. Is this policy available in other parts of British Columbia?
Yeah, that's a great question because it adds another layer onto what the Residential Tenancy Act affords tenants when
Mhm.
it comes to relocating for redevelopment purposes. So one thing is that I want to catch or address is that the term renoviction. So we throw that term around a lot. You'll see it a
Mhm.
lot in newspapers and it's kind of fun to say and we associate it with evicting for the purpose of doing renovations. But really the renoviction term has a sense of operating in bad faith. So I'm being evicted not for significant repairs or renovations, but for cosmetic changes, and I shouldn't have been evicted to begin with. So that's what the term renoviction means. But if your landlord is actually demolishing or redeveloping the property, then yes, the Residential Tenancy Act requires 4-month notice in order to do it. Robert covered beautifully the requirements for significant repairs and renovations to get RTB approval first before issuing that 4-month notice, or if it's for demolition purposes, getting your permits all lined up before you issue that eviction notice as well. But as an added layer, on the municipal level, and the city of Vancouver is a leader in that regard, there's been tenant relocation packages or plans that have been developed as well. So apart from what the Residential Tenancy Act says, some of the requirements on developers is to go a little bit step further, whether it's providing additional compensation to tenants or assistance with moving or help finding another property. Basically going above and beyond what the Residential Tenancy Act dictates in the circumstance. Keep in mind too that tenants typically have a right of first refusal as well, so they can bid on moving back into a property when it's redeveloped. But depending on what municipality you're in, you're going to be subject to different benefits packages, so to speak. So what is in play in the city of Vancouver might not be in Burnaby or Surrey or anywhere else. So great question. You just basically need to consult with your municipality to see what package I'm entitled to. And I should say when landlords are applying for these permits, so when they're applying to redevelopment the property, they're going to have to show proof that they have given their tenants proper notice and that they have given compensation or moving expenses in order to get those permits and approvals in place as well. So there's just another check and balance there for landlords that want to redevelop their properties.
Beautiful. Thank you so much, Lisa. And I'll just note that in the chat, there was a link placed to the tenant relocation and protection policy. This next question is for you, Robert, and a landlord asks, is there anything a single low-income senior who accidentally became a landlord can do if a renter is now demanding double the security deposit back due to the landlord not knowing about the rule where they have to return the deposit within 15 days or the tenant can apply for double the deposit back?
A big red flag in that question would be who accidentally became a landlord. So that would be kind of I'm not sure how that would come about, but I suppose these things sort of happen from time to time. But in this situation, basically, unfortunately, it's a requirement for the landlord to return the security deposit or apply for dispute resolution within 15 days of the tenant's moving out or receiving the tenant's forwarding address in writing. So whichever one of those comes second. If the landlord fails to do either, the tenant has the right to apply for double the security deposit. So my only suggestion would be to this person would be, if you're unsure about any process or requirement, contact the RTB as soon as possible, and get informed.
Thank you so much, Robert. Is there an opportunity to dispute that if it sounds like the former tenant has demanded the double amount? What happens next for the landlord?
So basically, it all depends. So there is a bit of an expedited process for this. So we have a direct request process for having the landlords return the security deposit, where as long as the tenant has all the appropriate paperwork, so copy of the tenancy agreement, proof that they've given the forwarding address in writing, proof of service that they've sort of served this to the landlord, then the process is basically it's adjudicated. It's not arbitrated. So an adjudicator would review these documents and potentially award the tenant double without the landlord's participation whatsoever. Otherwise, if they didn't have the documents, they could apply for dispute resolution. The landlord could submit a formal claim, or claim against it if they were trying to keep the security deposit. But the reality is that the tenant's not awarded double because they left the unit in spick and span shape. The tenant's awarded double in this situation because the landlord failed to go through the proper procedure for handling the security deposit.
Beautiful. Thank you so much, Robert. Lisa, we have one last question that came in advance, and then we're going to turn to the Q&A that came in today. And so, Lisa, this question is from a landlord. If a landlord wants to move into the rental unit, how long must they live in the unit so that the tenant won't have a claim against them?
These questions are funny because they start to question the intention, the intended use of the property. So if you're planning on living in your property, you don't really ask up front, how long do I have to live here to avoid a statutory penalty? So a bit of a red flag there. So as Robert mentioned before, when a landlord is moving into the property and they've issued the notice, they've given the tenant the 1 month's rent compensation, they have to move in within a reasonable period of time, and that's assessed according to the circumstances at hand. And they need to live there for at least 6 consecutive months in the next year. But that's the minimum. And so I think there's an argument to be made if it looks like there is an ulterior motive for the eviction, or if there is a for sale sign that gets posted immediately at 6th month mark or 5 months and a couple of days, then it starts to question whether or not there was a good faith intention to actually live there. But yes, I mean, the minimum is 6 consecutive months. I would say if you do intend to live there, just keep living there. And you don't need to worry about the statutory penalties that attract.
Beautiful. Thank you so much, Lisa. So this next question, I'm just reading here. I have a question about, this is the most upvoted. I have a question about the rental unit inspections. My tenants and I have an agreement for monthly inspections of the rental unit. Every time we agree on a specific time slot and I drive there, the tenant is not home. And if they answer the phone, they say that they won't be home for a long time. This happened not once, but a few times. I feel they might have something to hide. How can I make them do their part so that I can do the inspections?
So firstly, in their if they have that as an addendum in the tenancy agreement, that's not enforceable, because you can't require, you can't set a date more than 30 days in advance to do an inspection. So if it just says we're doing monthly inspections on this date and that's given more than 30 daes in advance, then it's no longer valid. So what it is the landlord has to give proper notice, and this is a bit of a tricky thing, and this is a very common question is landlords will often text their tenants or call their tenants, and those aren't actually proper notices to do any kind of inspections to enter the unit. So the landlord needs to make this request in writing. So they could put it on a piece of paper and they can give it to the tenant and they can enter 24 hours later. They could put the piece of paper on the door and they can enter 4 days later, or they can send it by email as long as they have that agreement that Lisa mentioned earlier about serving documents via email. They could serve that request via email, and they can enter 4 days after that. But you can't have a term that requires them to allow you into the unit in advance. That would contradict the act. So if you want them to participate, or if you want to access the unit, you just need to serve the notice properly. And if you serve the notice properly, you can't. The tenant A cannot refuse you access, and B, they don't need to be there if you want to do the inspection. So as long as you serve them properly, you should be able to. You should have no issues accessing the unit.
Beautiful. There's a follow-up discussion on this question, which I'm going to turn to, and Robert or Lisa, feel free to answer it. And it's the type of inspection. So what exactly are and are not permitted during the inspections? Open cupboards, closet drawers, and the landlord here is saying just walking through the apartment, opening doors, but no drawers or cupboards unless the tenant wants to open a cupboard or drawer to show me something that's broken and need repairs. So what are the requirements, or are there any, in terms of the nature of the inspection that the landlord would conduct?
I think one of the questions is what is the reasonable purpose for which you're accessing the property? And so that's actually the language under the act, is that there has to be a reasonable purpose in advance for conducting the inspection. Landlords don't have the right to inspect somebody's personal belongings. So we're not going to be opening up dressers if they're not part of the what's provided during the rental, but they could look into closets. So if they want to make sure that the property itself that they are providing is in a reasonable state of repair and maintenance, and they have the right to inspect their property. But they do need to be very clear, and I like clarity in those notices. Why am I getting a condition inspection? What will they be looking at? Who will be coming with me as well? As Robert mentioned, tenants don't need to be there when they're given notice that discloses the date and the time for entry and the reasonable purpose for entry. But I always encourage landlords to be cooperative as much as you can when you're conducting these inspections. Someone might not want you coming in because of concerns about COVID, or concerns that their property might be tampered with, or what have you. And so part of my goal, if I'm a landlord, is ensuring everyone's comfortable with what I'm doing. So I'm very transparent. I'm telling them that who's going to come in, what I'm going to be doing. And if I can accommodate the tenant, then even though the law doesn't allow that additional measure, even though I'm allowed to walk in and conduct my inspection on proper notice, I work with my tenants. I want to make sure that they feel comfortable and knowledgeable about the process as well.
The next question is a question about, can you address rent increases to cover non-capital expenses for a long-term tenants, i.e. resided over 8 years? The government allowable rate does not cover my costs, as I have long-term tenants who won't move and won't agree to mutual rent increases.
Robert, did you want to comment first? Or?
Sure. Yeah, no, for sure. So, I mean, unfortunately, there's nothing under the act that allows the landlord to raise the rent for to bring it up to market value. So that's just not there. Like I mentioned earlier, there are some options if you're making capital expenses. There are some there, but really there's not a lot you can do with that. I believe that there is a newer option if you can sort of prove that you're going if you are basically running at a loss, additional rent increase for expenses. So The residential tenancy regulations allows landlords to apply for additional rent increases when A, the landlord has incurred a financial loss from an extraordinary increase in operating expenses for the residential property. So if you have costs that are like essentially going up, but they have to be extraordinary, the landlord has incurred a financial loss for the financing costs of purchasing the residential property if the financing costs couldn't have been foreseen under reasonable circumstances. So that's a big caveat there. And the landlord, as a tenant, has received an additional rent increase for the same unit. So there is an option there. It's the additional rent increase for expenses. It's the ARIE, and you can make that application online. And it basically yeah, you could sort of plead your case for that. Yeah.
One of the things the Act allows too is landlords and tenants can agree together for an additional rent increase. So that avenue is always there. Word of caution for landlords, you want to make sure that your tenant is educated when they're agreeing to an above statutory maximum for a rent increase. But I like it when people talk to each other in terms of what their financial situation is. So if a landlord's saying, listen, my strata fees went up, the utilities or my property tax went up, I'm really struggling right now with the current rent. I'm proposing doing some upgrades for you. And would you be at all amenable to a slight rent increase? You can have these dialogues. There's nothing wrong with having the dialogue. The Act allows you to have the dialogue. But yeah, Robert's right. It's very, very limited in terms of your opportunity to appeal to the branch and ask for something more than what the law allows, which is quite small. But don't ever discount the idea that you might be able to negotiate something reasonably with your tenants too.
Super. Thank you, Robert. Thank you, Lisa. Those are really helpful answers. This next question is, how can you monitor a landlord if he's saying that he's using the property for family use once you move out of the property? Lisa, do you want to take this one? Or?
Well, most people monitor by Craigslist, or they'll see an ad for reposting that they haven't actually moved in. I always let landlords know that your former tenants will be watching whether or not you use the property within a reasonable period of time, because they've relocated and they've absorbed moving costs and expense and hassle of moving out on the premise that you intend to live there. There's no real magic way to determine whether or not somebody has in fact followed through with how they intended to use the property. But one of the biggest ways to get a speeding ticket, so to speak, under the legislation is if you re-rent and advertise to re-rent, and a tenant finds that advertisement later and says, well, wait a second, you said you were moving in, so why are you advertising this property for rent at a higher amount to boot? So I think landlords just need to be very, very cautious. If you are moving into the property, please move into the property. Please use the property for the stated purpose on the notice. And then we can avoid a lot of discord and potentially a 12-month rent penalty at the branch.
Yeah, this seems to be a common theme of today is do what you say you're going to do, and communicate about it as well. Robert, I'm sorry, I cut you off. What were you going to say?
I was just going to say I had a friend who was a landlord say to me on the weekend that their house is in Victoria and they had recently moved back into their unit using the 2-month notice process, and the tenants had moved to, I don't know, Dawson Creek or something like that. But the tenants came last weekend and had a picnic at a park adjacent from the house and just monitored the house all day to try to see and try to catch the landlord not following through with their with the conditions of the 2-month notice.
The landlord should have joined in on that picnic and said, thanks for coming back. You brought a housewarming gift for us.
Absolutely. So this next question, different theme. If you have a tenancy, and it sounds to me, if you have co-tenants, so if you've got 2 tenants on a lease and one of them leaves, does the other tenant have to vacate, and i.e. is the lease terminated, or can the remaining tenant keep the lease and stay on? Robert, you look like you're
sure. Yeah. No, so it depends if it's a fixed term tenancy or not. So basically, if 2 tenants, so just consider it like a partnership. If you are renting to 2 tenants, It's like a partnership, and if one person leaves, that partnership's basically dissolved, right? So in this case, you have a tenant. If they're on a month-to-month term and one partner wants to leave, if they give their notice in writing to the landlord that they're leaving, it applies to all parties. So the other tenant usually will have to leave at the end. Usually have to leave at the same time as the tenant that gave notice. If that tenant refuses, there is an option for filing for dispute resolution to get an order of possession based on the notice, the written notice that the tenant that's leaving had given. So that's one part. So second is a bit more difficult if it's a fixed term. So if it's a fixed term, saying that there's 6 months remaining on the tenancy, one of the tenants gives their notice. The remaining tenant can actually, the tenancy does end, but the remaining tenant can actually stay there until the end of the fixed term. So, but once the fixed term ends, then the remaining tenant is required to leave, and if they refuse, the landlord would be able to file for dispute resolution to get that remaining tenant out. Now, if you're a landlord and that's something that's happening to you, I would suggest maybe be careful when accepting rent from the remaining tenant if you want them to leave at the end of the fixed term, because there could be a chance of you reestablishing the tenancy when you're accepting rent from them. So what we typically say to landlords is just make sure that you're giving them a receipt that says for use and occupancy only, anytime that they're giving you money after that, to ensure that the tenancy does in fact end at the end of the fixed term. And another very, very, very common question we get with this is, one of the tenants has left, but they haven't given notice. So we find this with couples. They'll rent the unit together, and the couple will split up after a few months, but the landlord is never informed. So because nobody has given written notice, then the landlord can't end the tenancy because of that. So that the person who left is still liable for any costs incurred by the remaining tenant. But if they don't give notice, then they're still on the tenancy agreement, and the tenancy can't end under that sort of rule under the act.
One of the great things that Branch has as well are policy guidelines, and they actually have one that covers this. So they have a co-tenants policy guideline that answers all these questions. What happens if a co-tenant issues an eviction notice, a notice to end tenancy? Do I have to leave too? So everything that Robert discussed is actually in the policy guideline. So have a read after today's session. The other option too for landlords as well is you might like the roommates that remain there and want to entertain entering into a new lease for the same rental unit. And that's perfectly acceptable as well. But yeah, check out the policy guideline, because that's a good resource for you. And in particular, before you embark on an application for dispute resolution, you might want to have a look at what the branch's take is on these questions first, so that you're equipped
Absolutely.
and knowledgeable before landing at a hearing and realize, oh my goodness, there was a policy guideline that covered this and my understanding was wrong. So
policy guideline 13 for that one.
there you go.
Beautiful. And I haven't seen if it's in the chat, but we will certainly put it on the page that hosts the webinar. So for anybody watching, we'll find that, and we'll provide a link to it as well. And it may already be in the chat. Thank you. This next question is, well, I'll let you decide who's going to answer it. It's my first time as a landlord having to serve a 10-day notice to end tenancy for unpaid rent. Rent is 21 days overdue. Since the day of that notice, 4 days have passed. I've received no communication from the tenant, and there is no payment coming. I know they need to pay within 5 days or dispute the notice. How will I be informed if they apply for a dispute? They stopped communicating with me. What should I do in the meantime to get my rental unit related expenses covered and to find out about the tenant's plan?
Yeah, tenants are afforded, when they get a 10-day notice for unpaid rent, there's a very, very, very quick period of time that they have to either dispute it or pay the outstanding arrears, all of the outstanding arrears owing under that 10-day notice. If they don't, then the law deems that they've accepted the notice and they need to move out by the effective date of the notice. Now, for landlords, the branch, and maybe Robert, you can comment on that, there can be a lot of backlog there. So it's possible that your tenant has actually disputed the eviction notice and you just don't know about it yet. So typically what we do is before we make the next step, which is applying for direct request, order possession and monetary order, when a tenant doesn't dispute a 10-day notice, then the branch actually allows you to do sort of a trial by paper. So you can file a whole lot of required paperwork to get an order of possession and a monetary order if a tenant does nothing to dispute that 10-day notice or pay up their arrears. But typically before I do that, I'll give the branch information line a call and see whether or not do they have anything indicating that a dispute has been filed for my property or involving me. And I find you guys very helpful, Robert, in terms of answering questions. And sometimes it's just, it hasn't been processed yet, or it is being processed.
Beautiful.
Exactly.
And we have, it's amazing, time has flown by. We have just a couple of minutes left. So there's one question that I think is relatively quick to answer, and then we'll wrap up the official webinar today. Is it legal to deactivate a tenant's fob for unpaid rent, as the concierge often does this at the request of owners?
All
Nope.
right, Robert, do you want to
Nope.
tackle? Yeah, no, I was going to
No.
just say blanket no, don't
No.
do it, don't do it.
No, don't do it. You could potentially end up getting the compliance and enforcement unit involved if that happens. So basically preventing the tenant from accessing the unit is pretty serious. And that's something that would be something severe enough for our compliance and enforcement unit to investigate. And they have the power to potentially levy administrative penalties up to $5,000 a day per contravention for non-compliance. So I would highly discourage anybody from doing that.
If you have to ask about, for example, turning off the lights, changing the locks, otherwise barricading the tenant from the unit, you're probably asking the wrong question. You probably shouldn't. You've got the answer already. Don't do it. But there is relief at the branch. So if in that scenario, if you haven't been paid rent, then you can apply to regain that rental unit back. So follow the proper channels.
Beautiful. Thank you so much, Lisa. Thank you so much, Robert. It has been such a pleasure. Thank you, everybody who joined us today for today's webinar, for all of the questions that were submitted ahead of the webinar, for all the questions that were submitted today. We appreciate them. We've answered as many questions as we could for today's webinar. Thank you, and have a wonderful week, everyone.